Hello, this is R.J. Deacon reading the Supreme Court of the United States opinion syllabus in Holguin-Hernandez v. United States. Certiorari to United States Court of Appeals for the Fifth Circuit. Argued December 10th, 2019. Decided February 26th, 2020. A criminal defendant who wants to preserve a claim of error for appellate review must first inform the trial judge of 1. The action the party wishes the court to take, or 2. The party's objection to the court's action and the grounds for that objection. That's Federal Rule of Criminal Procedure 51B. Peter Holguin-Hernandez was convicted on drug charges and sentenced to 60 months in prison and 5 years of supervised release. While he was still serving a term of supervised release for an earlier conviction, the government asked the district court to impose an additional consecutive prison term of 12 to 18 months for violating the conditions of the earlier term. Petitioner countered that 18 U.S.C. Section 3553's sentencing factors either did not support imposing any additional time or supported a sentence of less than 12 months. The court nonetheless imposed a consecutive 12-month term. Petitioner argued on appeal that this sentence was unreasonably long because it was greater than necessary to accomplish the goals of sentencing. Kimbrough v. United States. But the Fifth Circuit held that he had forfeited that argument by failing to object to the reasonableness of the sentence in the district court. The Supreme Court held a decision below is vacated and remanded, and Justice Breyer delivered the opinion of a unanimous court. Petitioner's district court arguments for a specific sentence, nothing or less than 12 months, preserved his claim on appeal that the sentence imposed was unreasonably long. A party who informs the court of the action he wishes the court to take, Rule 51B, ordinarily brings to the court's attention his objection to a contrary decision. That is certainly true where, as here, the defendant advocates for a sentence shorter than the one actually imposed. Judges, having in mind their overarching duty under Section 3553A to impose a sentence sufficient but not greater than necessary to serve the purposes of sentencing, would ordinarily understand that a defendant in that circumstance was making the argument that the shorter sentence would be sufficient and a longer sentence greater than necessary. Pepper v. United States. Nothing more is needed to preserve a claim that a longer sentence is unreasonable. Defendants need not also refer to the reasonableness of a sentence. Rule 51 abolished the requirement of making formal exceptions to a district court's decision, and, in any event, reasonableness pertains to the standard of appellate review of a trial court's sentencing decision. That's Gall v. United States. It is not the substantive standard that trial courts apply under Section 3553A. A defendant who, by advocating for a particular sentence, communicates to the trial judge his view that a longer sentence is greater than necessary, has thereby informed the court of the legal error at issue in appellate challenge to the substantive reasonableness of the sentence. Other issues raised by the government and amicus are not addressed here because they were not considered by the Fifth Circuit. The decision below is vacated and remanded. Justice Breyer delivered the opinion for a unanimous court. Justice Alito filed a concurring opinion, in which Justice Gorsuch joined. Thank you for listening. If you'd like to get a hold of the podcast, we can be reached at rhodesscholar80@gmail.com. That's ROADS and 80, or on Twitter at Court Syllabus.